morning, everybody, and welcome to this episode of the New Possibilities Hour. Today is April 14th, 2022, and we have our own Jean Lawler presenting to us what I know is going to be a fantastic presentation on the mediation of privacy and data security and all manner of other cases involving things online. And let me just punch up Jean's biography here. And though I know her so well, I want to get this right and make sure that I'm introducing her properly to you. So Jean is a commercial and insurance mediator based in Los Angeles. She's well familiar with the intersecting fields of privacy and cyber-related losses and claims, both as an advocate and as a mediator. Jean first became involved in this area in private practice when the field was in its relative infancy, handling cases involving situations such as an escrow company who was taken in by an email to wire escrow funds to a bad actors bank and a major property management company being sued for alleged TCPA violations. With the rise in ransomware and data breach claims and understanding the value that a knowledgeable mediator could bring to these claims, she used the time during the pandemic lockdown to accomplish her goal of becoming certified as an information privacy professional, CIPP, by the IAPP. Jean has been a full-time mediator since 2017. She mediates privacy, data breach, and ransomware claims, among many, many other claims, particularly in the insurance field. When in practice, Jean was senior partner of a Los Angeles-based litigation firm with a diverse and international practice representing corporations, professionals, nonprofits, individuals, and insurers in a broad range of matters at trial and on appeal. She also served as managing partner of the firm for 5 years from 2008 through 13. Jean has had a number of leadership roles in the legal community. She's a past president of both the Federation of Defense and Corporate Counsel and the InsurLex Global Insurance Group. She's also a fellow and a founding regent of the American College of Coverage Counsel. Jean, I know you're going to give us an absolutely fantastic presentation today, and it's all to raise money for food banks. This is part of the Little Work for Food project founded by Natalie Armstrong-Motin in 2020, and you joined the team in 2021, and Sarah Agamiri joined the team in 2021 as well, all for the better. And we've had so many generous contributions to food banks in honor of our wonderful speakers. Natalie, I think you've got the latest total. Could you please fill us in as to just how much our generous audiences have contributed in honor of our great speakers?
Jeff, it's absolutely my pleasure. And a lot of this is, of course, due to the work that you and Jean do. And so I want to, with great happiness, report to you that we have so far been told about $266,611 raised for food banks worldwide. Thank you so much to all that you do, Jeff and Jean, all that you do, because of the great efforts that you all put forward every day and every week. We've really made an impact.
Fantastic. Thank you all so much for those generous contributions. Jean, we're also interested in hearing about, very interested in hearing about cybersecurity, data breach, ransomware, and related claims, how to mediate them, how to settle them. Please tell us about the food bank to which you would like us to direct contributions. The floor is yours.
Thank you so much, Jeff. And hello, everyone. It's great to see you today. It's 8 o'clock in the morning here in Los Angeles. It's a beautiful day. The sun is out, and it's just a great day to see all of you. So thank you. For the food banks that I have chose for today to suggest for donations, it's the World Food Program. They have emergency things where you can donate to specific emergencies. So the World Food Program Ukraine emergency and the World Food Program Afghanistan emergency. There are many other countries, of course, around this world that are in desperate straits for so many reasons, so sad. But those two in particular stand out to me, the hardships that the people from both countries are enduring and the hunger, the hunger. Last week, it was over $8,000 that was raised during the 1 hour of that speaker's program. He was a Hungarian attorney and arbitrator. And so I would challenge this group, let's go to it. The link, Natalie will put it in the chat, and you can let Natalie know, just send her a chat or something if you've made a donation. That would be great. There's no pressure to do that though, and I'm just so happy you're here. So thank you. So with that, let's get started and let's talk privacy. First, let me share my screen. Just a second here. Okay. Can you see my screen now? Yes. Okay. So these various logos and pictures here are from the IAPP, the International Association of Privacy Professionals, which if you are involved in the privacy field and are not a member, I highly recommend becoming a member, or if you want information about privacy in general, it's just such a huge area and it's only going to get bigger, then I really recommend that you take a look at that website, iapp.org. Okay, and you'll find all sorts of things. But today, we're going to focus on mediating privacy, data breach, ransomware, cyber insurance claims. Again, the field is so huge. And so taking that one little niche there for discussion. But of course, with that, you do have to have a background, right? And what we're talking about. So let's see here. Okay. Whoops, sorry. Let me go back here one. The elements of privacy. What is privacy? You may as well start at the very beginning, right? With the definition. Well, the little graphic here for privacy, what IAPP has put together is that it stands for protecting information vigilantly, and that when you do that, that achieves compliance. Right, to get the Y in there. But privacy is a noun. We think we all know what privacy is. Well, here's the definition. All right, state or condition of being free from being observed or disturbed by other people, the state of being free from public attention, and then all kinds of synonyms here for the word privacy. But the word privacy, the concept of privacy, the reality of privacy, that is what is at our core for all of this and for everything. It all flows from privacy or the invasion thereof. All right, so Tim Cook was at the IAPP annual meeting this week, and on Tuesday gave a fascinating speech. I watched it on YouTube yesterday, and I'm going to play a little clip here for you. Let's see, let me get there.
You look fabulous.
Yes, you do.
Welcome,
here
welcome
you go.
today. Please join me in welcoming to the IAPP Global Privacy Summit, Tim Cook.
Oh, goodness, sorry.
Good morning. It's a privilege to be here with all of you in the nation's capital. And I must say, it's so nice to finally gather in person. I want to thank the IAPP for bringing us together and for the vital work you do every day. And thank you especially to Trevor for your leadership. The fight to protect privacy is not an easy one, but it is one of the most essential battles of our time. And we at Apple are proud to stand alongside all those who are working to advance privacy rights around the world. As a company, we are profoundly inspired by what technology can make possible. But we know too that technology is neither inherently good nor inherently bad. It is what we make of it. It is a mirror that reflects the ambitions and intentions of the people who use it, the people who build it, and the people who regulate it. Out of this paradigm have grown two disparate coinciding realities. One where technology unlocks humanity's full creative potential and ushers in a new era of possibility. The other where technology is exploited to rob humanity of that which is foundational, our privacy itself. And that is a loss we cannot accept. Because it is our privacy that gives us the freedom to explore different ideas, to indulge our curiosity, to dream big and take chances and make mistakes. It is privacy that lets us be and become ourselves without being afraid that our every move will be seen, recorded, or leaked. A world without privacy is less imaginative, less empathetic, less innovative, less human. At Apple, that is not the world we want to live in. We believe that privacy is a fundamental human right.
A fundamental human right. Yes, in California, the Constitution itself says that the right to privacy is an inalienable right. California, I think, is one of the unusual states, or one of the few states that actually has a right to privacy in its Constitution. Now, as an example, and again, just getting used to all the different areas that are involved here, there are, of course, all kinds of federal privacy related lawsuits. This is what I just refer to as an alphabet soup of US federal privacy related laws. You've got them in all sorts of areas: medical, financial, education, telemarketing, et cetera, et cetera. We're all familiar with HIPAA, I'm sure, but we're not all so familiar with other areas. And you won't be, there's no reason to be, I suppose, unless you're working in this area. But if you are mediating cases that come out of any of these statutes or that involve any of them, you will need to become familiar with them. The state laws in the United States, let me say here, there's at this point there is no federal rule or federal legislation regarding privacy in the United States as there is in Europe. A Microsoft executive at the same IAPP meeting where Tim Cook was speaking also spoke, and he is highly recommended, called for some sort of federal law. I suppose that will come. It's inevitable as far as I'm concerned. But in the meantime, we do have states that are in various places of implementing, various stages of implementing privacy laws. And the IAPP, if you are interested, does have this tracker on its website. It has a lot of other information too, but this is effective as of April 7th. The states that had passed legislation, others who have it in progress, inactive bills, et cetera, where different things are happening. So it is something that is sweeping across the United States, and that also will play a role in the various types of litigation and claims that are made. So why do breaches happen, and where are the exposures? Well, they're everywhere. And, when you walk out to your car today, you'll get into it and just see how smart it is. Your phone, look down at your phone. Is it talking to you? What's Siri have to say today? What's Alexa doing at this point? I love these, what they call them stickers, because every single one of them, these stickers from the IPP, they all talk about something that is involving a risk. And every one of these risks has the potential to have a cyber incident or a data breach that in some way then will affect ultimate claims, litigations, and mediations. It all just flows. So you've got the doctor here. Don't worry, be HIPAA. Okay, you know, you have breaches of medical information, private personal information. That could be something that ends up in litigation. The biometric, the just the simple things as a password not being changed, people being able to hack computers, tracking, which is of course huge now, and being able to turn off tracking on your phone or not getting consent to share certain information, phishing emails, all sorts of things. So this right here just is a picture probably of what types of claims will be emanating from situations that you could then be mediating, whether you're the attorney, whether you're the party, your company's the party, or whether you're the mediator. So who's at risk here? Who would be the parties in these mediations? Essentially, all businesses and service providers. You've got managed service providers, you know, the ones who manage servers, and again, just thinking small business for the moment, small, medium-sized businesses. Do they just happen to have a server sitting in their, you know, back office or in a closet somewhere? Or do they have an actual IT company that's managing for them? Do they have IT folks themselves? It's certainly advanced beyond the reboot stage when you would call the IT guy to come up, please, there's a problem with my computer, and the answer would always seem to start with, it would get to be a joke in a way, not in a bad way, but just in a humorous way of, okay, reboot, now let's see where we are. So businesses of any size, but professional service firms, schools, hospitals, infrastructure. And now with these warnings, with the war in Ukraine and the warnings about more cyber incidences and all, I think that, you know, we've seen already, we've seen and experienced with the oil pipeline, was it just last year, I think, you know, what this could be. It is critical to know, to be able to resolve a claim, to be able to bring a claim properly. Was it a cyber incident or was it an actual data breach? Was data compromised? Privacy always goes back to the data. That's not to say that a cyber incident in and of itself won't trigger a lawsuit or a claim that then would result in a mediation or, you know, trial, whatever, because it often will, usually will, I'm sure. Somebody didn't do something they should have done, probably would be the argument. But what type of information, you know, calendar, documents, photos, graphics, chat, but the key is, are they accessing credentials and are they accessing confidential personal information and records along the lines of, you know, the financial, the health, the educational, the business, government documents, things like that. This all plays into the scope of the claim, the lawsuit, and then any ultimate mediation. So then once a breach or loss has been contained, which can take a while, what comes next? That's when you have your governmental investigations, and then ultimately people, companies, businesses, insurers, looking to the next guy over, their neighbor or their contractor, their vendor, you know, who's liable, who caused this, and what are the resulting damages? And so you have all sorts of lawsuits. I've listed a couple of types here: lawsuits against the insured, maybe by an insurance company over coverage issues rising out of the incident or the breach, lawsuits by the insured against others for subrogation, reimbursement, breach of contract, professional negligence, insurer subrogation lawsuits when the insurers have paid a ransom perhaps, or paid for data breach losses, notification, things like that, those sorts of things. And then insurer versus insurer lawsuits, who's on first, so to speak, and could more than one insurance policy apply? So this is just, but you know, a general list. I'm sure the imagination can run wild and think of others. Obviously, the bad guys are not the ones that are going to get sued. Maybe some countries could get sued, but that one might be a long shot, like the terrorism lawsuits. But in any event, a long shot at recovering something, I should say. These are typical lawsuits. You would, of course, have class actions in that mix as well. So what types of exposures directors and officers are exposed? They could be the parties who have been hacked and end up being sued. Professional liability, the managed service provider, the one who's handling the servers, for example. Vendors, that's huge. You can have one vendor who doesn't have the proper security, and maybe they're handling things for a number of companies. They, whatever, click on the wrong thing on an email, or they haven't patched properly. Tuesday, so I understand it is Microsoft's patch day. If you don't download your patches, you may have some problems, you know, things like this. And then that can affect everybody that is in their network, and their computers, their servers, things like that. Third-party providers, cloud companies. And what types of claims would you have against them? Well, we've touched on a few, but breach of contract is, of course, going to be there. And it is surprising to me. I've run into some of these cases where there's no written contract for services to be provided. It's all oral, or additional tasks were taken on by the service provider. You know, have a written contract for sure. Negligence, professional negligence is a big one there. Management negligence, and then fraud and misrepresentation gets thrown into the mix on these as well. And the kinds of damages would be everything from attorney fees and fines, violations that, you know, have to be paid under governmental laws, but then also anything that was paid, whether it was a ransom that was paid to the bad guys. And I say bad guys because even though that's really a term of art, the threat actors, the vocabulary plays a part in this. We'll just call them bad guys for right now. So, you know, the ransom that's paid, the cost of having to do notifications, all sorts of things, the investigation costs into the millions. So as part of and preparation for mediation, it's very important to know the possible sources of insurance coverage. This particular chart is 5 years old now. So I say that with a big grain of salt because policy terms and conditions and wordings change regularly. But this was an example of what could be silent cyber coverages. And for anyone going into a mediation over a cyber privacy data breach type of claim, your lawyers need to, and the parties, of course, by this time should have figured out what insurance policies are available, and every single policy needs to be reviewed. And then those insurers whose policies might provide coverage, even if they may not, if they might, put them on notice. So cyber insurance, you can see here, this is the area here for, say, cyber insurance in this graphic. And then this is where it might overlap. You might have overlapping policies, kidnap and ransom, crime and fidelity, you know, employee embezzlement or theft, some financial types of things. Under the property, you certainly see business interruption types of claims, maybe some other types as well. Again, every policy is unique. There's no such thing as one particular kind of policies, even if it has the same name on it as, you know, the business owner next door. It's specific to the insured's risks, the terms, the conditions, the endorsements, and the like. The terrorism policies, general liability, professional indemnity, professional liability, E&O policies, and then of course the D&O and the workers' comp. Now, they call these the silent cybers from the, especially the older policies. And if you do have a case with older policy, you're more likely probably to find some potential coverage on some of these other ones because they don't directly insure for cyber. And now most all of these policies have evolved to specifically disclaim or eliminate in one form or fashion coverage for cyber claims, and you need to look to your cyber policy. So, but the lesson on this is look at it all and make sure that you report to your insurer ASAP when the claim is first coming in, because they are the cyber insurer is definitely your friend. Or any insurer who's going to pick it up is definitely your friend to help get this going. And they'll be the one that insurer who pays something will be the one sitting in the mediation room with you, trying to get money back probably against the person who is allegedly liable. From this perspective, then the ultimate takeaway for all businesses is if you can't protect it, don't collect it. It's always the information that's lost that is the problem. And so what would often come up can come up in these lawsuits and the litigation and the lawsuits, litigation, the mediations is, you know, what exactly was lost? And it can take a lot of time and investigative forensic investigation effort to figure out what was lost. And if your computer, for example, had been encrypted, and so the threat actors couldn't get into it, so they couldn't collect any private personal information, then you're in much better shape than if they could. If they were able to get in and got names, email addresses, phone numbers, social security numbers, whatever, you know, any of the private personal information, then it's a different situation, and it's not the best, obviously. On this, I would just say, you know, having a good system to go through the computers and delete things that are not pertinent anymore, you know, it would be very good. So against that backdrop, let's talk about mediations. They happen years later. So hold on, let me get rid of my screen here. Stop sharing. Let's see. So, sorry about that. Yeah, the little thing is covering my stop share button. So against that backdrop, then let's talk about the mediations that result. You know, they come years later after payment of money. And, you know, we've talked about the various kind of money that can be paid. Business has been lost, time has been lost, people have been impacted. There may be lawsuits going on that are peripheral to your particular mediation. Maybe yours is just one of many that a particular defendant is facing. There was a lawsuit that just received a jury verdict March 31st. It was in Kansas City, I believe, and it was by an insurer who had sued their defense counsel. That particular breach, I'm looking at it here on a different computer, that particular breach, according to Law 360, happened in late 2016. And so here we are, March 2022, this case did go to trial. The insurer seeking money from its insured law firm to recover for its own investigation costs and the like. That particular jury came back in favor of the defense firm, the firm, saying that that insurer was not entitled to reimbursement. And there are reasons for that, like who's responsible for what. Presumably that case probably went to a mediation, but it didn't settle. So when you get, as a mediator, when I look at these cases, you know, I want to know, what's the status of the case? Where is it right now? What's the type of case that it is? What's the nature? Was was it an actual data breach? Was it just a cyber incident? We've talked about that. What sorts of claims are at issue? Is there a written contract? One would assume that there should be, but there may not be. So don't forget to ask that question, you know, and again, I'm thinking of service providers and vendors and things like those types of relationships. But then professional negligence. I have found that so many of these mediations, they really come down to a commercial business dispute that has its own area of not just vocabulary, but also the risks and the exposures and then what's paid out and the like. So you're really talking negligence is always involved in these, as well as contractual. And, you know, was it a professional negligence? Is it, you know, the IT company that's handling the servers that we've talked about? Is it a managed care provider? Is it a hospital? Is, you know, just what is it? So you need to know the it. The it being what happened, who's involved, and then what do they have in common before you can even get into understanding probably what's at issue. What's at issue will always be money if it's a civil lawsuit that's coming to mediation. And so then you can understand where the money came from that is being sought to be recovered by somebody, or the invasion of privacy that's being asserted by somebody. Using the subrogation types of cases, for example, and in Law 360, either yesterday or today, there was an article, Cozen and O'Connor's law firm, talking about cyber insurers should embrace subrogation lawsuits. I do see those. They are out there. And basically, whoever has paid money out, whether it's an insurer, a business without insurance, or just the business itself, because probably the business is out of money as well as the insurer, even if there is an insurer there. They want to get their money back from the tortfeasor, or the contractor, whoever it might be. And I had mentioned before the insurance coverage suits. Just because there's insurance doesn't mean that it applies to a particular loss, which is of course also the reason to understand what it is. It may be that you know, you see these insurers who are suing each other. Preparation for the mediation depends on what happened. Educate the mediator on the history. What happened and why are we here? Who are the players? What's the causation, the liability? Is again a cyber incident, a data breach, whatever? Are there special terms, types of damages at issue? What's the source of funding for the settlement? Did the insurer, if there was an insurer involved, and the insured have some agreement about the funding? Are they splitting the money that comes back? In terms of contracts, the breach of contract types of claims, are there indemnity provisions in that contract? I mean, generally there would be, of course, but what's the scope of the services? That may be what the dispute is about. Are there addendums to the contract? Just because someone's an IT provider, they may say, well, I wasn't responsible for maintaining the security of the network for business XYZ, whatever. I was only responsible for hosting or doing something like that. What were the advertisements that then resulted in that business relationship between them? All of this will be very important, and also in terms of a product. You know, if a product was meant to say, oh, we're going to for sure stop data breaches this way or that way. You know, people make representations, and maybe there's a little, you know, claims of fraud, misrepresentation. Those are there. In the policy, for the looking at the policies involved, which the mediator should have, and of course counsel should already have this. Make sure that you're familiar with the insuring agreement, the scope, because the scope of the contract for the work that's to be done would tie in then with the scope of the insurance that's being provided. Conditions in the cyber policies now, as in any policy, there are conditions, but my understanding in these cyber policies now, there are many conditions that you've, you know, you've maintained your network, your computer systems, you've patched, you've kept up certain security levels. And if you haven't done that, then that can be a breach of a policy condition. So it's very important that the insurance aspect of it is not left just to any one aspect of the company, not just to the CFO maybe who's signing off, or the CEO or the IT team. It needs to be really the company's lawyer needs to look at that, but then it needs to trickle down so that all the requirements are met so that they do have that insurance. But essentially what is it, who, what, when, where, why, and how? Those are the questions in any commercial mediation, and probably in life in general when there's a dispute. So those are the questions that you need to know, who's involved, what happened, when did it happen, and what was done next? Where did it happen? Do you have jurisdictional issues? Perhaps, for example, and how did it happen? That goes into fault and liability along with why it happened, fault and liability. I mentioned this one lawsuit here with the insurance company that sued its defense counsel. Excuse me. And if you can Google the law firm is Warden, W-A-R-D-E-N, Greer, G-R-I-E-R. And you can Google that. There are a number of newspaper articles about it and what the jurors thought after the fact. Excuse me. In the ransomware cases, I mean, that's another aspect in and of itself. And that's a topic of conversation that consumes many hours, of course, in programs and study, etc. But when there's been a ransom, you'll hear, you want to know whether it was paid or not, who paid it, was the key to unlock the computer system, in a little more plain English, I suppose. Was that actually received? Did it work? You may have an argument by a defendant who's being sued for reimbursement of the price for the ransom that was paid for the key. Well, that key unlocked everything that was involved, say for an IT provider, a managed service provider. So it unlocked not just my business's computer, but and server, but it unlocked, all these others as well, everybody that service provider was managing. So why should I pay for the whole price of the key, so to speak? So you can get into that type of argument and debate too. If there is an insurance company involved in that type of thing, those ransoms are generally huge. They may very well be full policy limit types of situations. But there may be many claims against that against that defendant, and again, the insured of the insurer. And just like a multi-car crash in a simplest example, there may be multiple claimants, and you have specific limits, only so much in insurance money, and then maybe the defendant doesn't have money to pay, or maybe they've gone bankrupt. Maybe they do have money. If you're the plaintiff, you're lucky they do. But the money itself may not all be able to be, you may not be able to be fully compensated as a plaintiff, because the policy has to be spread out policy payments among multiple claimants, perhaps. So once you're in the mediation room, there's a lot that transpires. I would just say that as I have been saying, I suppose, the type of case determines what the discussions are. Is it first party? Is it, business interruption? That's a discussion in and of itself. Is it a third party case, like I've been talking about with claims against somebody who is probable or potentially liable? But like negotiating, I would tend to say that it's like any other deal. And I don't mean to minimize these claims, but ultimately, any sort of commercial claim, any type of lawsuit, excuse me, has its unique characteristics. And these types of claims are no different. But when you get past the unique characteristics, they ultimately come down to people who are claiming to have been wronged and damaged by someone else or a business. And how will that defendant be able to compensate that plaintiff for the harm, the injury that they have suffered? So the unique criteria. A couple of takeaways. I think that it does help if the mediator has an understanding of the terminology of insurance, of the industry involved. You know, a claim involving the healthcare industry is quite different than, you know, a property management kind of industry or something like that. And so having some familiarity with that industry, especially if that industry has its own vocabulary and nuances, as of course most industries do, you know, that can be and is very helpful. I highly recommend pre-mediation conference calls with the mediator, perhaps a joint one initially, making sure everybody has the documentation or the damage information that will actually help get the case settled. In one of my mediations in particular comes to mind, where we did this about a month before the mediation, and I had both sides, the attorneys for both sides on that call. Sometimes they want their clients on, whether it's a risk manager or the general counsel, whoever as well, that's fine, whatever works. But they were able to work out then and talk in a safe place between themselves, with me participating as necessary and as appropriate, to work out what documentation had been given to the defense for them to evaluate. And remember, if an insurance company is involved, they need time to evaluate. Oftentimes these will be roundtabled or whatever. It's not something that you can throw at a defendant on the day of the mediation and say, here are my damages. Share and share alike in advance. But I do recommend that, and I do think a joint call can be helpful. But then I also do the individual calls, generally a week ahead of the mediation, making sure that they've got what they need, any ideas or thoughts they might have. And then oftentimes those can lead to additional fact finding or document getting or whatever it might be that will then help the mediation. So that is for ahead of the mediation. I do think also, and of course you would all think so as well, it's so important, and it cannot be understated, that the right people are in the room, the decision makers, whoever they might be. And that would include an insurer if an insurer is involved. So it could include multiple people, and it is so important to nail that down ahead of time and make sure that the parties involved, the attorneys, are thinking about this far enough in advance so that the decision makers can get it on their calendars so that they are there to be able to then participate actively and with information, make informed decisions about what to pay, what to accept, what to do. There are many resources out there. I know I've mentioned the IAPP. There are many, many law firms that have whole pages devoted to these issues of privacy, data breach. I mean, the field is so huge. You can Google that and come up with many of these wonderful areas. Perkins Coie has a very good page. Hush, I've never said it out loud, I only read it, Hush Blackwell. If I'm pronouncing the first name of that firm correctly, they've got an email that comes out every week, I think. It seems like it's out pretty darn regularly about latest developments in this field. And ultimately, as Tim Cook talked about, the beauty, the need for privacy, the value of privacy, every one of us in this field, no matter what our particular job area might be, our task might be, but together we are all fighting for privacy, to respect privacy, and to stop bad guys and hopefully make those who are negatively impacted by data breaches, cyber incidences, the like, hopefully to make them as whole as possible. And so with that, I thank you.
Thank you, Gene. That was terrific and comprehensive and informative on so many different levels. We have a number of questions in the chat. Let me start with one going a little bit out of order that David Baca asked. David asks, as a professional mediator and arbitrator, what type of information do you keep and not keep on your computer system so that you minimize your risk of a cyber attack or breach, especially since you are such a high-profile professional? In essence, what best practices do you recommend for our industry?
Okay. Hello, David. Well, without getting into complete specifics, I mean, I always do my updates, of course, on my laptops, on my iPad, you know, all my personal devices. I mean, that's pretty darn basic right there. On my email, I do have it encrypted and I have it backed up. I have that sort of thing. You know, everything's password protected, of course. And I know that there are, and people would recommend using those password services where you can put them all in one place. Just on a personal level, I don't, but I've got a whole host of those, and I don't keep the passwords on a little yellow sticky on the front of my computer. I check. I use only programs that are based. Well, I check where things are housed. You know, where the housing is. Some programs or apps that you could use, they come from other locations. And for me personally, and even following the European rules, I think it's better if you've got your data housed in your location, you know, wherever it might be, where it would be protected by privacy laws. I'll be happy to talk to you offline in more detail, but I definitely try and keep everything as protected as possible. I delete, for example, with the mediations, you know, I delete the mediation briefs and things like that that I get because everything's electronic. I will keep the if it's a court mediation where I had to file something, I keep that. Anything that's public record that might be necessary, I keep it all in an encrypted area anyway. You know, you don't need those mediation briefs, notes, things like that, at least not for too long. And again, I'm talking commercial types of mediation, maybe you do for family law or something, but I don't do that. So Jeff?
Gene, it's important to take those precautions to protect ourselves. And on the subject of protecting ourselves, Bill Haber asks that sometimes it can feel like working in cybersecurity is a finger-pointing witch hunt looking for scapegoats. What advice do you have for cybersecurity professionals to minimize proactively the likelihood of litigation when acting as a vendor, an advisor, MSP, etc.?
Yeah, that's tough. I had another company I started after I left my law firm at the end of 2016, and it was doing a project for a business, and we did it for about 2 years. And I'll tell you, their security, because they're in the financial industry, it was an insurance company. The security was just amazing. I had to submit all kinds of things, do testing. You know, they would do the tests. They have an IT guy who would come in and do this for me. My suggestion would be, make sure you understand what your contract obligations are, you know, and be clear. Have a contract that is very clear about what you're supposed to do or what you're not supposed to do, so that there could be as little gray area as possible if or when something happens. And then, you know, I mean, that to me is the whole key. Make sure you have insurance as a backstop, cyber insurance, and then other insurance. I know I've come across in some mediations, there's managed service provider, professional liability insurance for managed service providers. Have a good insurance broker. Get the broker to look at whatever insurance may be available for you. It's certainly helps you sleep at night. But then look at your contract and follow your contract. Do what you're supposed to do. Document things. Make sure it's very clear. And then don't do make sure your people have training. Make sure they understand not to click on a link in an email. I mean, it's human error that is that's the cause for the majority of incidences when the bad guys get into your computer system. Those would just be a few of the things that I would suggest.
Okay, Jean, another question. Are there mediation opportunities during the risk management or containment phase immediately after the cyber event, but before there's litigation?
Definitely before there's litigation. I'm not so sure it's during the containment period, because I think that they need to, they need to be able to have cap their damages figured out, not capped as in limited, but as in stopped, I guess, stop the flow of the money before they can know what's really what. And the investigation, the forensic aspect needs to be investigated too, before you can really talk turkey about it. But I have found that so many of these, most of the mediations I've done have been pre-suit or pre-arbitration, if maybe there's an arbitration clause in an agreement. And that's another thing. If your agreement has a clause in there requiring mediation before going to arbitration or even to suit, make sure you do that, because you can waive your rights to attorney fees or other things if you don't do that. So I would say definitely pre-suit is very common and I would recommend it.
Okay, and one more question, Jean. What type of policy coverage do you see being triggered for business email compromise or wire transfer fraud?
Well, I can't give legal advice anymore, right?
You can have thoughts and opinions.
I have thoughts and opinions, yes. I think you look to your cyber policy and make sure that it's got the proper endorsements, social engineering, and reputational loss. See if you can get that type of coverage under a cyber policy, for example. But again, back to a good insurance broker that can advise you as to what insurance is available, because this field is growing every day.
Okay, we have a couple minutes left. If there's anybody else who has a question, please feel welcome to unmute yourself and ask your question. Anybody?
Deandra Roche has a question. Deandra, if you'd like to unmute yourself, you can ask Jean directly your question.
Thank you. Hi, Jean.
Hi.
Do you have any suggestions for like a good cyber insurance company or broker for our profession that you can recommend? Because I see they kind of run from various levels, so not quite sure what I would be looking for. So any suggestions would be helpful. Thank you.
Sure. Rather than naming any particular company, because there are so many of them out there, so many wonderful companies, it really depends on, your need. But basically, I would think that you would want some type of both first party and third party coverages. The first party would be if your computer system gets hacked, let's say the most elemental, and information gets out, whatever. So the first party, they help you then with figuring out the breach, helping to pay for notifications if you need to do that, reimbursing you perhaps for business interruption, money to help get your system back up. And I'm speaking in generalities. Every policy is unique. And so, you really have to look at the terms and conditions. But I think it's very important to have first party insurance for yourself in these policies, which they typically provide. And then, of course, the third party insurance in case the third party liability aspect of the cyber policy, which if somebody sues you would provide you with the defense. And then with indemnity, and then pick out, you need to choose your policy limits. But it's so important, and I can't say often enough, look at the conditions of the policies and make sure that you are complying with them. You know, and then the policy limits, however much you might be able to afford based on the premiums. The bar associations, organizations, the Association of Attorney Mediators has a policy, group policy that's part of that. But then there are just so many companies that offer them, and they're, you know, good companies. You'll find what you need. But those two types of coverages, and add on, if you can, the social engineering, which is like the phishing emails and all, and reputational harm. Those two types of things, they may be by endorsement.
Okay, Maria Luisa Galazzi, please unmute yourself and ask away.
Hi there, Jean, fabulous presentation. And this is the cyber is an area I do a lot of practice, and I just had a thought specific for mediators, which is there are a lot of times where the cyber coverage is bundled in with a technology errors and omissions for companies that provide tech services. And it may be that the place to start with is the E&O provider that you already have for your mediation practice, and ask how that policy can be augmented with additional coverages for, you know, first party and other loss and things like that. So that may be a good starting point and easily accessible to this group.
Yeah, absolutely. Thanks, Mary Louisa. Fellow members here of the American College of Coverage Council. So that's totally apropos. They're great advice. And it is part of the professional liability coverages added on, for example, on the Association of Attorney Mediators policy as well. Excellent. Yes. All right. Anything else?
Jean, what about cases where there's a data breach, but nothing seems to happen to the consumers? Their credit card information may or may not have been pirated, but there's no fraud on their credit cards, their credit's not impaired. What are the approaches in settlement and mediation in those kinds of cases? We read about that.
Yeah, and you know, obviously I haven't really addressed class actions. They're a beast unto themselves. You know, we all get our little thing in the mail or in the email, right? We might get 79 cents or something, you know, from a class action settlement. To me, you either opt in or you opt out. I guess you opt out generally, although sometimes you have to opt in on those. You know, those mediations involve big money. There's an article in Law 360 today about lawyers that are asking for millions and millions of dollars for fees following a settlement in one of those huge class actions. You know, I just think from our perspective, I don't know if I'm like others, but yeah, they happen. I change my passwords. And then the notice comes in and I generally ignore it, but maybe I'll take the 79 cents. I'm not involved in that mediation generally either. I'm sure there are probably particular people that have carved out those niches. You know, the big MDLs or the huge, massive class actions. Where the action really is, though, is in the everyday cases. The claims are numerous. They're just numerous and growing.
Okay, thank you very much. There's a terrific presentation, Jean. We hope people are able to support the Ukraine Emergency Fund of the World Food Program or the Afghanistan Emergency Fund of the World Food Program. Natalie has posted the website links for those organizations in the chat. If you're in a position to contribute to either of those organizations or another food bank of your choice in Jean's honor, we appreciate it. We thank you. And if you let Natalie know about that, we'll be delighted to add it to our running total. Thanks again to you, Jean, to Natalie and Sarah for founding and running this great program. And it's a joy to be part of it. With that, we are complete.
Thank you all. It's great to see you. See you next Thursday. Bye.